For everyone who's joined so far, we're just going to give 1 or 2 more minutes for to give people a chance to join, and then we'll get started with this episode of the Burr Morning Show. We're just going to wait 1 more minute before we get started. There's a few people that are logging on here. Okay, guys, we're going to go ahead and get started. Thank you for joining us on this Friday before Thanksgiving week with our latest installment of the Burr Morning Show. My name is Emily Mack. I am a partner in the Nashville office of Burr & Foreman, and I am joined today by Kate Hamilton, who is also in our Nashville office. And we're going to be talking today about the very exciting topic of drug-free workplace policies and marijuana. This is a rapidly evolving topic and seems to change every time we touch on it. And so I'm excited to be joined here today with Kate to talk to you about this. We're going to go ahead and kind of jump right in to this subject. You know, one of the things we're going to touch on is kind of how evolving standards of marijuana use have changed and how that has then kind of driven changes in the laws that we have seen at the state and local level. We're going to talk a little bit about pre-screening candidates for marijuana, the challenges that that poses, how employers can kind of grapple with these new laws in light of pre-employment drug screening, and reasonable suspicion testing as well. We will take a look at accommodation issues and some recent cases that have discussed those things, and then also focus on some emerging trends and best practices as you continue to navigate this area. And I will say that, you know, for those of you who have offices here in Tennessee, you know, this is something that probably before the pandemic, we weren't having to pay employers who were Tennessee only employers weren't having to pay as much attention to. But I think that as many employers now have started to begun to embrace more remote work and have employees that are in different jurisdictions, this is certainly something that everyone needs to be aware of, because it is something that is changing very fast on a state by state basis. Would you agree with that, Kate?
I definitely would. And yes, as Emily said, I'm Kate Hamilton and I'm in the Nashville office. And I'm excited to talk to you guys today. So like Emily said, this is definitely a rapidly evolving landscape. Even I think since COVID from 2020 until now, like looking at the numbers, they've kind of drastically changed. And so we have some statistics here that can give you a little bit of an overview of generally where people are leaning. So right now, 69% of Americans favor legalizing marijuana. And we'll talk a little bit later about the difference between recreational and medical marijuana use, because there's definitely more states and legislation that we've seen towards the medical side of that, but definitely a good number with recreational use as well. And then 58% of Americans agree that marijuana is less harmful than alcohol. And there are 55 million current users in the United States. So this was kind of surprising to me. It was much larger in a lot of ways than I expected. But again, it's good to keep an eye on this, because I imagine that it will kind of keep trending upwards, because that's kind of what we've seen lately.
Kate, you said I think one of the first things you said was that these numbers have gone up even since COVID. Is that did I hear you correctly?
Yes, that is correct. And
COVID made people use more marijuana. Is that what I'm hearing?
That definitely could be true. And I'm not sure, I'm sure there's a lot of factors that have gone into that, but I think the working from home, working remotely, I don't know what impact that has had, but that's true. They have definitely gone up a pretty significant amount. So, or
maybe just being forced to be under, stay-at-home orders with one's family members and children. Who knows? All right. Well, let's take a look at some of these categories of legalization.
Okay, great. So there are 4 general categories of legalization of marijuana. And I think getting an understanding of the vocabulary can be helpful, because there's, people often use cannabis and marijuana interchangeably, but they're actually 2 distinct things. And so marijuana is referring to the parts or products from the plant cannabis, whereas cannabis is referring to all products that are derived from that plant. And so if you can kind of wrap your mind around like what those words actually mean, it's easier to understand like why states have kind of what they're allowing and why they're passing certain legislation. So just in the federal context, marijuana is listed as a Schedule I drug under the Controlled Substances Act, which means that it is deemed to have no medical value and a high potential for abuse. And then CBD or low THC products are cannabinoids with little or no intoxicating effect. And then medical marijuana is referring to the whole unprocessed marijuana plant or its basic extracts, and it's used to treat symptoms of illness and other medical conditions. And like we've said a little bit, this is kind of the most popular kind of legislation that we will see being addressed is the medical marijuana. And then recreational is using the whole plant without medical justification. So we'll kind of dig deeper into seeing how these are applied, but that gives us a good starting point for the overview. Okay, so here it was helpful, I think, to kind of see how this is applied practically. So again, a lot of changes recently, even from 2020 in states, but those 4 categories you'll see on the side of the screen there kind of depicts where the states are. So this might not surprise many of you, but we can see there's kind of a pattern based on the region of the country. So in the Southeast, you can see it's a lot of CBD or low THC, and then comprehensive medical marijuana programs. And then you'll see in states like California, Arizona, Colorado, it's medical and recreational use. And then there are very few states now where all forms and uses of marijuana and THC remain illegal. But Emily is going to talk in a little bit about the Tennessee legislation so that because I know that is probably what a lot of us are interested in, but we can even see in Tennessee recently, they have allowed CBD and low THC products. So it's evolving.
It's a very rapidly evolving, I think, even since, even as I'm looking at this chart, I think Kentucky has, in the last, few days, the governor there, has passed an executive order or signed an executive order, attempting to, authorize some type of medical marijuana program. I mean, most of this legislation that we are seeing is being passed by state legislatures. I don't know that I've, and I haven't delved into this, that I've seen a governor trying to sign an executive order trying to authorize a medical marijuana program. It will be interesting to see, if that goes into effect. I think it's supposed to be at the new year, and it will be interesting to see if that's subject to some type of judicial challenge. I would imagine that it very well could be, but that's just, gives us an example of how, quickly this map is changing and how fast these laws can change in this area for sure. So let's talk a little bit about the categories of the laws that we are seeing, and I kind of like to analogize this to some of our, fair chance and ban the box laws. The first wave of that type of legislation was very much aimed at prohibiting employers from asking about criminal history, before a conditional offer was made. That was called, ban the box. And that was really where that legislation stopped and started. Once an offer was made, you could ask a candidate anything you wanted to about criminal history, and there wasn't any, protections or prohibitions on rescinding an offer to someone, based on criminal history. Then the second wave of legislation in states that started passing protections in that area kind of involved more Fair Chance Act, individualized inquiries and protections and restrictions on your ability to rescind an offer of employment. The medical marijuana legislation that we've seen is similar, right? The first wave of states that passed protections for medical marijuana cardholders, were what I will call zero tolerance statutes, which meant that even though the state recognized the right of an individual to use medical marijuana, it did not impose any obligation on an employer to accommodate an individual for doing so. You could refuse to hire someone who had a positive drug screen. You could discipline or terminate them. There was no protection that was afforded to the user by virtue of their the fact that they chose to use medical marijuana. And so those are kind of the first category or type of legislation that we saw be passed in the earlier states that recognized protections for medical marijuana. The second wave of legislation is went a little bit further than that, and it says that an employer can't discriminate against someone based on their status as a registered cardholder or solely because they test positive for it. So that leaves really room for litigation, in my opinion, as to whether or not an employer who takes an action, based on some type of positive drug screen has in fact discriminated against someone, or there's another not legitimate, non-discriminatory reason for the action that is being taken by the employer. And really, until you see more reported case law in those states, it's going to be hard to define if you are an employer in one of those jurisdictions, where that line is. The newest type of legislation that we've seen in different states, really contains explicit protections in the statute itself that requires employers to reasonably accommodate the medical needs of cardholders. Now, what do I mean by that? There is not a single state law for medical marijuana right now that requires an employer to accommodate any employee's on-duty use of marijuana. You don't have to allow someone to be impaired while they are at work. What I mean by reasonably accommodate is that if someone is a medical card holder and does have a legitimate, has that status, that if they are using medical marijuana off duty, then that you have to accommodate that. You can't just take action against them because they are using marijuana outside of work hours. Now that becomes really tricky in terms of how do you enforce a drug-free workplace policy, because what we'll talk about a little bit later in this presentation, the fact that marijuana stays in one system for a longer amount of time. We don't have a current testing mechanism that can determine active impairment like we do for alcohol. And so, that becomes, that can become tricky. And we'll talk a little bit more about how you can deal with that as an employer. But these are really the three types of categories of legislation that we are seeing here today. So in terms, this is a graph that just kind of depicts really where states are falling in terms of 40 of them currently legalizing medical use of marijuana. Of those 40 states, 17 have explicit non-discrimination protections. That's that second category of legislation that I talked about in the last slide. And then 6 states do offer protections for off-duty use of recreational marijuana, that you can't, again, if the state has legalized recreational marijuana and, someone is failing a drug screen without active any evidence of active impairment, there are protections in those states for those individuals. Nevada prohibits taking any adverse action based on a positive pre-employment drug test result. That is similar to New York City's ban on pre-employment drug testing for marijuana. In New York City, if you have an employee there and you are subject to that law, it is a per se violation of the New York Human Rights Act. It's discrimination, in fact, to run a pre-screen drug test for marijuana. So if you are an employer that does do pre-employment drug screening, it's very important to make sure that whatever CRA you're working with to do your drug screening, or if you're working with local drug screening agencies, you need to make sure that they are aware of these laws and you're not inadvertently ordering a drug screen panel that would include marijuana in one of these jurisdictions that would prohibit you from doing so. That's kind of where the law is going in this direction. I will also note that even in the states that don't have explicit, non-discrimination protections or affirmatively require an employer to accommodate the off-duty use of medical marijuana, the court decisions are signaling very much a shift in favor of employees in this area. And the reason for that is that these cases are not being brought under the medical marijuana laws. They are being brought under the state counterparts to the Americans with Disabilities Act. And so that even if the state statute is silent on reasonable accommodation of off-duty use of medical marijuana, the cases are being brought under the state equivalent of the ADA, which often contains a reasonable accommodation component to it. So if you are in a state, and we're going to be, I've probably already gone there, we're going to be focusing, the remainder of this presentation really on medical marijuana, because that is where the accommodation issues come into play. It's where the drug testing issues come into play with taking adverse action. Again, unless you're in one of these, 6 or so states that really prohibit you from taking action based on recreational marijuana use.
Okay, so we've been hinting at this a little bit so far, but basically the trend that we're seeing is a shift from pro-employer to pro-employee based on the laws and cases that we've seen recently. And so that kind of goes back to the categories that we see states fall into, where it started with the first wave of like, a little bit, and then we've seen that progress more and more. But basically, it seems to hinge a lot on the pre-employment drug testing and what actions employers can take with respect to screening potential candidates or individuals that are already employed at the workplace with respect to marijuana use, and particularly medical marijuana use. And so there is an increased pattern of employers not being able to eliminate otherwise qualified candidates just based solely on a positive marijuana test. But then also with the recreational marijuana, there's a shift towards protection even there in that arena, which we haven't seen quite yet, but we think it's only a matter of time until a state tries to protect recreational users from employment decision, as well as with the medical marijuana use. So definitely, this is something to keep an eye on, and there's case laws continuing to emerge and laws are continuing to be passed, but there is definitely a shift from pro-employer to pro-employee.
Right, absolutely. So let's talk a little bit about, this testing challenge, right? And, this is what really kind of exacerbates, not only do we have a complicated legal landscape when it comes to, can you do pre-employment screening, for marijuana? And then the other question is, should you? I know that we have a lot of clients who have just chosen not to pre-screen, not to do pre-screen employment testing for marijuana, and that's driven by a few factors. I think this is one of them. And then the other main one is depending on your industry, you have a really hard time finding qualified candidates, that can pass. And we are in a labor shortage. And so that is really driving, there's business reasons and justifications that is driving this shift away from doing the pre-employment screening, for marijuana. The other thing I'll say about that is when we get into the accommodation issues in terms of, do you have to accommodate the off-duty use of this? If you don't pre-screen, if you don't perform pre-employment, I'm saying pre-screen, pre-employment drug testing for marijuana, if you eliminate that from the panel that you're running, you're not going to know someone's a card holder. So you can't discriminate against them based on their status of being a card holder, right? So what you eliminate by virtue of that is, is having to go through the reasonable accommodation analysis and determining, is this something that can be accommodated? So I think it is behooves employers, to go ahead and take a look at, are there positions for which this isn't necessarily, it's not necessary anymore, right? And you're still going to have safety sensitive positions. You're still going to have positions where you do want to perform this. And I will also note that most of these state laws that we're talking about have explicit statutory carve outs for safety sensitive positions. Similarly, and I'm probably getting a little bit ahead of myself, but if you're subject to federal laws in terms of being, subject to the DOT or a federal contractor, these state laws also carve that out. All right, but going back to the testing issue, the fact is we do not have a current test for active impairment. Marijuana can stay in one system for a very long time, a month or more. And so we also know that CBD, which is legal, and is not the same as marijuana from what Kate touched on earlier, it's poorly regulated. So sometimes it can be contaminated with THC. So even if someone is using, a legal CBD substance, they could have a false positive result, or, in my opinion, a positive drug screen, if that happens. So now, if I am able to fix this problem and to, develop the test for active impairment by marijuana, I will be resigning from Burr and Foreman and will live a very happy life. But it's not there yet. We don't have it. I haven't heard of any news of when that might be coming. So what does an employer do, in the meantime? We know that, as I said before, there's not a single state law that says that an employer is legally required to tolerate any on-duty use of marijuana, active impairment, by this substance. In that respect, it's going to be, if you can treat it just like alcohol, right? If someone shows up intoxicated, you can take action. But what this means, because you can't any longer just send them for a reasonable suspicion drug test, and if there is a positive result, you can't just take action based on that in and of itself, based only on the test, because we know that marijuana can stay in their system for up to a month. So if they're a card holder, of course they're going to test positive. They're going to deny that they were actively impaired on the job, and they are going to instead say, that I was only using marijuana outside of work hours. So what this means is that for employers who want to take action based on suspicion of impairment while on the job, you really need to be focusing on your reasonable suspicion indicators of impairment and making sure that's well documented. You want to make sure that your supervisors and your managers have training on how to detect impairment from marijuana, and that, ideally, I have developed forms for my clients, where you have a manager and ideally 2 managers, because a lot of this is very subjective. Strong odors, questionable movements, twitching or staggering, dilated or watery eyes, flushed, confused, blank facial expressions, slurred speech, being argumentative, irritated, or drowsy. I mean, some employees are just argumentative, irritated, and drowsy every day, right? So you can see how these become, this is a very subjective determination that is being made to try to say if someone is actively impaired or not. So making sure that you have 2 supervisors who have received training on how to detect active impairment, going through and filling out that checklist is going to put you in a much better position than simply where in the past, before these laws were passed, you could just rely on the fact that you have a positive drug screen, take adverse action against someone for being actively impaired on the job, and not have to worry about any type of liability resulting from that. So I think that really making sure you have good training in this area and good practices and policies is going to help, especially if you're in one of those in an industry with this is a real concern from a safety standpoint, and it's something that's a recurring issue. Going ahead, investing in that training for your managers. And making sure that you have those policies in place is going to help mitigate any type of claims that might be brought by a cardholder, asserting that this is really just discrimination and this was a pretext to discriminate against them based on their cardholder status.
Okay, so these are 2 statutes that have been recently passed that have been helpful to kind of shed light on how states are approaching this issue. So first in New York City, and we touched on this a little bit earlier, but in May of 2020, New York City law went into effect banning all pre-employment marijuana drug tests for job applicants. So it's important to note this law does not impact an employer's ability to test current employees. It just applies to prospective applicants, but it applies to marijuana and THC. And so it does cover the spectrum there of what they can test for related to marijuana. But like Emily said, a lot of the statutes that we've seen continue to have carve outs for certain things, like safety sensitive positions is something that we've seen a lot of exceptions geared toward. And then also any jobs that are regulated by federal programs that require drug testing, those are going to trump laws like this, like the New York City law. And then in November of 2022, so very timely for us, Washington, D.C. has passed a law that is a little bit broader than the New York law, just because it applies to current and prospective employees. And so it bans employers from firing or failing to hire or taking any other actions like that for an individual's use of cannabis or participation in a medical, cannabis program or failing to pass a marijuana drug test. And so this law went into effect yesterday, November 17th. And again, it doesn't apply to safety sensitive employment positions. But something that's interesting about this statute is, I mean, it has the carve out for safety sensitive and then for federal regulations, but it also has an exception for if an employee is impaired by use of cannabis while working such that their job performance is substantially lessened. And so I think this is going to be something to pay attention to see what courts do with this statute. I'm not sure, what factors are going to come out and how it's determined that their job performance is substantially lessened, but I think that it's all kind of part of the issue to keep monitoring it and see what courts are going to say and how this is going to play out in the long term, because I think, again, it is subjective. And I think different states have different laws, different courts are going to, maybe interpret this differently, but it is interesting and definitely getting broader than where we were with New York City just 2 years ago.
Yeah, and the other thing that's tricky about these are at the local level in some ways, right? We're seeing New York City, and so we're seeing some of these. You have to not just be paying attention to the states that employees are working in, but in the localities that they're working in. Which, of course, it's again, we've seen this with the Fair Chance Act stuff. It's making it even more burdensome on the employer to be able to maintain compliance in this area, because these things can just kind of quickly pop up and you may miss it. But going back to the DC law, and I want to talk about another one, which is Illinois. The challenge that employers are going to have in a post-accident or a reasonable suspicion, for instance, like a post-accident drug test or reasonable suspicion drug test, is proving impairment. The test alone is not sufficient. And so, we had a question here from one of our attendees that if a post-accident drug screen comes back positive, would reasonable suspicion of impairment be assumed based on their involvement in the accident? What other considerations are needed? I don't think that based on this, we can assume the fact that just because someone had an accident and just because they have a positive drug screen anymore, we can assume that they were impaired when it comes to marijuana. That's exactly kind of what the dilemma that is posed by this. What you would need are really, again, going back to the reasonable suspicion, having good witness statements, a good investigation that kind of where eyewitnesses are able to look and see, was this person exhibiting signs of active impairment? Were they stumbling? Were they slurring? Did they appear drowsy? Were their eyes dilated? How did they look right before the accident? How did they look after the accident? Did anyone witness the accident and observe behavior that would indicate, impairment? Those are the kinds of things that employers are going to have to be prepared to be able to prove, right? Now, this Illinois law, I really like, and I really hope that what we have are more states that move in this direction, because Illinois has kind of anticipated that this is going to be a problem for employers. And again, what we don't. The goals of these statutes are to ensure that people who have the right under state law to use marijuana, whether that is recreationally or medically, even more so, are then not, discriminated against or unfairly disadvantaged from employment opportunities as a result. The intent, though, is not to create, a situation for an employer where they can never take any action based on an employee who is a card holder, especially if they think that there is impairment involved, because they're afraid that the employee is going to turn around and sue them for disability discrimination, right, under the state law. And so this law is intended to insulate employers for liability when they are disciplining or terminating an employee based on a good faith belief that someone was impaired or was using marijuana while they're at work. And the statute says, what is a good faith belief? It's evidenced when an employee manifests specific articulable symptoms while working that decrease or lessen the employee's performance of the duties or tasks of their position, including, and then it goes on to kind of list some of these factors, One of them being involvement in an accident that results in serious damage to equipment or property or disruption of a production or manufacturing process. All of these, though, are still going to be case by case. Not any one single factor is going to be dispositive. And so if you have a situation, where you are in a medical marijuana jurisdiction and you have a reasonable suspicion scenario or a post-accident scenario involving a cardholder, it's going to be really important to make sure you document and investigate to the extent that you can to try to make sure that any evidence, of that impairment is gathered and preserved. Another thing you could do is you have the ability and should have the ability to perform a reasonable search, right? So does that person have marijuana or paraphernalia that is on them? That would help you in this situation, because again, even though they're a card holder, that doesn't give them the right to bring it onto your premises. It doesn't give them a right to use it on your premises as the employer. So thinking, outside the box about those types of things, when you have one of these situations, will help you better be able to kind of document your file and be able to support any conclusion that you may come to that someone was actively impaired, on the job.
Yeah, and I think, Emily, I would just add on to that and let me know if you disagree, but I think based on the cases that we're going to talk about in a couple of minutes, I think courts tend to look at what evidence an employer has that it's based on something other than just that positive drug test. So I think if we're waiting until there is a positive test result and then it's like, oh, actually they are impaired and here's all the symptoms and signs that we've seen of their impairment, I think it is really hard for a court to kind of look at that and say like, oh, that makes sense if you don't have that documentation and kind of like a trail leading up to that test result of, that you can show the court, because it is so subjective. And, the test that we have for this is not as easy to kind of look at as a document that's saying like, look, here's where we've marked like up until this point. So I think that's kind of how courts are looking at it. And we'll talk more about that in a minute, but I think definitely just having that positive test result and then after the fact saying like they are impaired is not as convincing to a court as, having that documentation before.
Right. And so if you have anything that you can point to outside of a positive drug screen, you should be okay. We have to remember courts don't sit as super personnel departments. They do not get into questioning, was our good faith belief wrong, right? I mean, we could be wrong about whether someone's impaired, but as long as we have a good faith belief that they were, that's the standard. So what are you, employer, relying on outside of that positive drug screen to support your conclusion? And that is going to require some level of investigation on your part. And if you do that investigation and you reach a conclusion that, the person was impaired and your policy was violated, a court should not be questioning, that conclusion as long as you've gone through that process and done so in good faith. So we'll talk a little bit, I want to talk a little bit about, how this impacts the federal law, right? If you are in a state that is not a medical marijuana jurisdiction, the law is the same. Under the ADA, there is no obligation to accommodate use of medical marijuana. There may still be a duty to accommodate an underlying medical condition, right? But not when it comes to use of medical marijuana. So if you're in a non-medical marijuana jurisdiction and you have an employee that fails a drug screen, that you can take action on. So if someone, even if someone goes to a state where marijuana is perfectly legal, they go to Colorado for the weekend and they come back and they're subject to a random drug screen, you can still take action against them based on that, right? If you are in a state that, that doesn't, permit the allow or require any accommodation for off-duty use, right? So if you're in Tennessee or state like that, no obligation. Similarly, if you are subject to the Federal Drug-Free Workplace Act, contractors and grantees are required to adhere to that. And so there is no obligation there to accommodate the use of medical marijuana. So that's the good news for those of you who, do not have any employees that are in a medical marijuana state, or are concerned that, the ADA or cases might interpret the ADA to require that. Now, if Congress decides to the reason that we don't have any obligation under the ADA is there's an explicit regulation in the statute that says that so long as something is a controlled substance, a Schedule I controlled substance, there is no, that is not something that an employer is ever going to have to accommodate. That's an illegal drug, and the ADA doesn't cover illegal drugs. If that changes, then we may have cases under the ADA, but I don't see that happening. Certainly, I don't see it happening, in the next couple years. It may happen eventually, but not right now. So that's good to know.
Okay, so in October of 2022, President Biden issued an order pardoning all U.S. citizens with federal offenses for simple marijuana possession. And he encouraged states and state governors to do the same for individuals with state offenses for simple marijuana possession. However, after this was passed, the Tennessee Governor Bill Lee, his administration came forward and said that he does not plan to issue pardons for those convicted of simple possession in Tennessee. So this kind of highlights the dichotomy between the federal and state legislation. And again, I think with this issue, a lot of it is very state dependent. So, even with this executive order pardoning citizens with federal offenses, there's still so much kind of power that rests with each of the states, and they can make that determination, whichever jurisdiction they're in. But it definitely highlights kind of the contrast there. And then President Biden also requested that the Secretary of Health and the Attorney General do a review of how marijuana is scheduled and classified under federal law. And so it'll be interesting to see if and when that changes. I imagine that it will be a very gradual kind of process to reclassify that, but the fact that there is some movement and going in that direction, I think is really interesting. But again, even with that happening, states such as Tennessee, the state laws are so limited in kind of how they can decide how to classify and who to pardon, that it's going to be an interesting kind of transition to see how that plays out. So we'll just have to see how that goes.
We want to take a look at some of these recent cases. Okay.
Yes, sure. Okay, so first up, this is a New Hampshire case, Payne versus Brightaway Inc. January of this year, it was decided, and in this case, an employee was enrolled in a state cannabis program and used physician-prescribed cannabis to help treat his PTSD. And so he submitted a written request to his employer for an exception from the drug testing policy, and said, I have this medical condition, I use this regularly, prescribed by my doctor, and I think I should be excluded from this policy as a reasonable accommodation. The employee did not request permission to use cannabis during work hours and said, I agree to comply with state law on this. But the employer ended up firing him because he said he was going to treat his PTSD with medical marijuana. And the employer said, nope, violates our workplace policy, you're fired. So the employee brought suit, and the court looked through the language of the statute and said, on a case-by-case basis, the use of a therapeutic cannabis, which is prescribed in accordance with state law, can be a reasonable accommodation for an employee's disability. Now, it's interesting that they didn't say, there's no always is, or like this is a definitive, like it is a reasonable accommodation, but it's very fact dependent and very much a case-by-case basis. But essentially, in this case, the employee had a legitimate medical condition and was not trying to bring medical marijuana onto the premises or violate any state law on it, but was just like, hey, this is something that I think should be reasonably accommodated. And the employer was just like, nope, no questions asked, like you're out. So I think this case is interesting because the state law, there was no anti-discrimination provision explicitly protected in it. But the fact that the court still held that the use of therapeutic medical marijuana can be a reasonable accommodation, kind of shows that like how a court interprets the statutory language is not always just contained on whatever is in the statute, but a lot of it is like the application to the scenario that's in front of them.
Yeah, I think that's a critical point of this holding, Kate, is that the New York or New Hampshire law that we're talking about didn't have statutory language that explicitly said that employers cannot discriminate against a cardholder based solely on a positive drug result, drug screen result. And so this again is a perfect example of how you cannot rely on that if you're an employer and you are looking at these laws and engaging what actions you can take. That if it's not a state that explicitly prohibits discrimination, then you are free to take whatever action you want, which I think is the miscalculation that the employer in this case made. Instead, again, this case was decided under the New Hampshire disability law, which requires reasonable accommodation, and in this case, the court said that this would have been reasonable.
Yeah.
I think it's important.
And I think too, the fact that just factually here, I mean, he didn't even fail the drug test, or he wasn't even impaired. There was no not even a discussion of that being the reason that he was terminated. And so I think from that point as well, the fact that it was just a request to be exempted from the drug testing policy kind of was where the court said, no, like you can't do that. So.
Great point.
Okay, and then our next one is an Arizona case, Whitmire versus Walmart. This was in February 2019, so a little bit before our last case. And in this case, the employee was injured when a bag of ice fell on her wrist, and she sought medical attention 2 days later and was required to take a drug test and failed it because of medical marijuana. So in this case, it's interesting because the employee was a medical marijuana card holder, but the reason that she failed her drug test was for use of the medical marijuana to treat this specific injury. And so there was a lot of discussion about, whether she was terminated because of the cardholder status or whether it was because she used the medical marijuana to treat the injury. But ultimately she was fired because she failed the drug test, and the court again walked through the state statute on this and looked at the provisions there and said there was no evidence that the employee was impaired at work and that her termination violated the state Medical Marijuana Act. And so here, back to what we were talking about earlier about there needing to be more than just a failed drug test. In this case, the employer didn't even know that she was a medical marijuana user or card holder until she had failed the drug screening test. And she went back to work after she was treated, and there was no indication that she was impaired or unable to perform her job responsibilities. And so the court said, without more, it is not, it's unlawful for you to fire her solely based on this failed drug screen when there's no evidence that she was unable to perform her job. So again, in the state statute, anti-discrimination is explicitly protected, but the court construed, pretty broadly the language of that statute in applying to this employee's situation.
Right.
Okay.
Rhode Island case.
Yes, our last case here is Rhode Island, Callahan versus Darlington Fabrics. This was in May of 2017. And this involves an applicant, not an employee, but the applicant was applying for an internship position. And in her first interview, informed the employers that she was a medical marijuana card holder and would not pass the drug screen test. And so the employers refused to hire her because they knew that she would not pass the drug screen. So the employer said, made a big point in this case that it was not discriminating against her because it wasn't they kept saying, we're not, refusing to hire her because she uses medical marijuana. We're refusing to hire her because she will fail our drug test, which is, a violation of our workplace policy. And the court did not take favorably to that argument. It said there's really no distinction. By nature, a medical marijuana user will show up on a drug screening test. And so you're trying to make, something out of nothing here. And so the court basically said a refusal to hire this employee does violate the state medical marijuana law, and said that employers are explicitly prohibited from refusing to employ or otherwise penalize a person based solely on their status as a medical marijuana card holder. And so again, this case I think is interesting because it broadens the application to not just current employees, but also expands it to potential applicants, and kind of back to what we've been talking about, like if you have a qualified candidate that you otherwise would hire, and the only reason that you're not hiring them is because they are a medical marijuana card holder or they would fail a drug screen, that in and of itself is not going to be enough to persuade the court that you're doing okay. So that I think is the significance of this case, is that it was an applicant, and the only reason that she was not hired is because she wasn't going to pass that test.
Right. Yeah, I think the employer's argument here was a little too cute, and we have to remember that the courts are going to look at the intent of the statute. And really, I think this is another case that illustrates this shift in favor of employees when it comes to these types of laws. So we're going to switch gears a little bit and talk, about, Tennessee and where we're at in Tennessee. And just touch on this before talking about some best practices. One thing that's important to know is I'm sure a lot of you have heard this term like Delta 8. Like Delta 8 just seems like, we got, into COVID, and all of a sudden, this Delta 8 stuff is everywhere. And where did that come from? And as an employer, what does that mean, right? For those of us who are not marijuana literate, which it seems like is an entire just, practice area. But we had a federal law that was passed in 2008 that removed hemp from a list of controlled substances. And in doing that, individuals are permitted to purchase and possess and use CBD oil in Tennessee as long as it's derived from hemp and the THC concentration does not exceed 0.3%. So this is where Delta 8 in Tennessee and in other states has kind of become prevalent, is it's operating in this, loophole that originated from the Hemp Farming Act that was passed back in 2018. So now if you're an employer and you're saying, I had this issue come up the other day where an employee accidentally thought she was texting her husband and instead texted her supervisor and said that she had, taken a gummy. It was a really terrible day and she had taken a gummy, right? And so in that situation, she was maintaining that this was just CBD and this was perfectly legal. We sent her for a drug screen. It came back negative, so we didn't take any action. But because going back to the fact that, again, this is very poorly regulated. And so I am of the impression and belief that, if you're an employer and you're not dealing with a medical issue and you're not dealing with a state that has protections for recreational use of marijuana, and someone has a positive drug screen for marijuana, I don't care if they say it was CBD oil. I don't care if they what their argument is. That is a risk that they are assuming when they are ingesting, a substance. And if they know that they are subject to your drug testing policy, and you have a positive drug test that comes back, you are free to take whatever action you want to take based on, that drug screen. So, that's one thing I'll say about the Delta 8 and the prevalence of that in deal. But and the other thing I'll say is, let me go here and then I'm going to come back, because what I really want to talk about now is your policy, right? So most of you probably have a drug test policy that prohibits the use of illegal substances and also prohibits the use of legal substances if they are interfering with someone's ability to perform their job. And that gets at, prescription drugs that are, legally prescribed, but being abused or may impair someone while they're working, right? this whole Delta 8, CBD, T8, all of that stuff really requires you to go back and take a look at your policy and make sure that you have explicitly addressed those types of substances and that type of use in the policy itself. Because what we have is it's not going to be an illegal substance by definition. And yet, if you have a drug screen for that, you're going to be treating it as that. So making sure that you have cared for that and this shift in things like Delta 8 in from a policy standpoint is important. Another thing that you can do here, so I wanted to touch on that from a policy standpoint. I'm going to go back and talk real quick about where we're at again in Tennessee from a medical marijuana standpoint. Last year, the Tennessee legislature passed a law that explicitly states that a medical marijuana program is not going to be authorized under Tennessee state law unless or until marijuana is removed from Schedule 1 of the Controlled Substances Act. So what this means is that if you're a Tennessee employer, unless federal law changes, you aren't going to, unless the Tennessee General Assembly amends this law or rescinds it, we aren't going to have a medical marijuana program in this state, at least, until there's a change from a federal law perspective. So going back to some best practices here, certainly take a look at your policies, certainly take a look at training your managers on how to identify workplace impairment. That is going to be critical in kind of mitigating your liability in claim and in jurisdictions that have protections for cardholders. And then also kind of focus on the medical condition in these situations. Employers are very this is a big change for employers in terms of having to understand and think about marijuana not like other controlled substances that we would take action on, but instead viewing off-duty use of it is something that's permissible. And really, if you're in one of these jurisdictions and you're thinking about it in this way, what is the difference between someone going home and taking, a pain medication for a chronic back condition and going home and using medical marijuana to treat the same condition? That's how we have to be thinking about this. So as long as you can evaluate the essential job functions, and again, you are entitled as an employer in these situations to go through this interactive process just like you would for any other disability and any other condition. So making sure that you understand when the employee is going to be using this, making sure that you get in, if you need to get an opinion from the physician on their ability to perform the duties, anything that you need to do in that area to get comfortable with the fact that the employee can safely perform the essential functions of their job, even though they are may use marijuana off duty, is permissible, and then outline what that agreement is going to be with the employee, just like you would in any other type of interactive process, scenario. That's really going to be, kind of your best practices for managing a medical marijuana cardholder. We have another question here that I want to answer before we wrap up, which is that the question is if someone uses marijuana in a legal state and has a medical card, and then they fail a drug test in an illegal state, can you pull the offer? I mean, that's a very loaded question, and it's going to depend on what states we're talking about and exactly what the situation is. I think, my initial reaction is, what state is the employee working in? That is by default normally going to be the state law that governs the employment relationship. And so if that state is a medical marijuana state, then you likely will, should not be taking, adverse action based only on that positive test result. I would also say that out of an abundance of caution, though, some states like to kind of look extra territorially beyond their borders. New York is kind of historic for that in terms of saying, if you're a New York resident and you're working in a different state, we still think that your employer is going to be subject to our laws. And so you have to be really careful and as a best practice, I still think that you're better off, not rescinding job offers to someone who's a medical card holder based solely on that test result. You're better off looking at, something else, unless you're on really firm legal ground where that the state that is going to apply to that employee does not explicitly doesn't allows you to take an adverse action based on that employee as a result of the positive drug screen, right? And that if they're a card holder, most of those states and the courts that have looked at them from the decisions that we've examined today are going to say, can't do that, employer. You need to determine if you can reasonably accommodate, or you need to be basing your action on something other than just cardholder status. So I think, Kate, do you have any closing thoughts for people as they try to navigate this landscape?
Right. I would just say to monitor, especially the two statutes that we talked about with New York and Washington, D.C. Keep an eye out to see if the jurisdiction that you're in, what legislation they're coming up with, because as we have talked about, it can change so rapidly in a short amount of time. So I would definitely just keep an eye on the changes and monitor what courts are going to do with the statutes that have recently been passed. But I do think it's very case by case and state by state, which makes it more difficult for us because there's not like a bright line answer to a lot of these questions and situations. But yes, I think just pay attention to what's going on in your jurisdiction and your state. And yeah.
Okay, everyone. Well, that concludes this episode of the Burr Morning Show. We appreciate you joining us, and we hope everyone has a happy and healthy Thanksgiving holiday. Thank you.
Thanks.